Most people think parking charge notices are unfair, and some people even disagree that there is a formation of a contract when you enter a private car park to park there in the first place. So in this video, I'm going to go through a few of these things to dispel some myths and to discuss whether certain things are unfair, and some scenarios where you might be able to challenge it, despite the Supreme Court ruling, which I will also reference in this video. First of all, if you're new to me, I am Daniel Shensmith, a barrister of England and Wales. I very much enjoy helping you to understand law, so let's get into the meat of this video. Now, many people think that there is no contract because you haven't signed anything. Well, that's not true because you don't need to sign anything. These are known as automated contracts, either by paying at a machine if you do pay at the machine, or just simply by driving on and parking your vehicle. You're accepting the terms of the contract by your conduct, by parking the vehicle on the car park. Now that we've got that out of the way, there is a contract. Now, there must be, firstly, the offer, consideration, and acceptance. We've dealt with acceptance. The offer is going to be whatever the signs say. It might say customers only. Therefore, you can only park there if you're a customer. It might just say you can only park here for 2 hours. No other restrictions applied. But then you can obviously only park there for 2 hours. Those typically that will say pay and display, you can pay a certain amount of money, you're restricted to a certain amount of hours. There might be a leeway, there may not. Now, if you stay within the terms of that contract, then that's the offer. You park your car. You've accepted the offer to park your car there. And the consideration is, well, whatever it is. You get to park your car there. They get to have you as a customer, or the money, or whatever it might be. Now, as to whether those terms are fair or not, we really need to look a little more closely. But there's two things to consider. First of all, whether they were clear in the first place, and then going on to consider whether or not they were fair. And then I'll come back to the parking charge notice and whether that is fair. So let's look at the terms first of all. When you drive onto a car park, typically you have the sign greeting you on the entrance to the car park, making the terms clear, usually on a big board these days in large enough font that you should be able to read it without getting out of your car, going up and reading it with a magnifying glass. Now, in addition, there are usually signs dotted around the car park so that when you park, it is sufficiently clear for you to see those signs from wherever you're going to park or wherever you walk about. If they are not clear, or the writing is not big enough, or the terms are vague, or any number of other things, even one fairly obscure argument such as they don't provide the proper address for the parking management company and it's only a PO box. A PO box is not acceptable. So you shouldn't really be able to form a contract with a company that doesn't provide their actual address, as in a geographical address, and a PO box is not a geographical address. That's another argument that we'll come back to in another video. But assuming these signs were clear and assuming the terms were clear, and so you've now got those terms to comply with. So all of that out of the way, it's now you in the car park and those terms. If, let's say, it is customers only and maximum 2 hours, then you, first of all, can only park there as a customer. You may or may not have to pay, and you're limited to 2 hours parking. Let's say you overstay that by, let's say, 15 minutes. So 2 hours and 15 minutes you come back, there's a parking charge notice on your windscreen. Is that fair? Well, then that depends on a couple of things. First of all, is the amount the same as it was that it was warned to you in the signs in the first place? For example, £85. I'll use £85 as that was the example used in the Parking Eye and Beavis case that went to the Supreme Court. And consideration whether that was a penalty or not and whether that was fair or not. So assuming that it is the same amount that was warned to you on the notices in the first place, i.e. you breach the terms, we will charge you £85, then we consider whether that or not is fair. If, on the other hand, it's £300, that's likely to be unfair because it would be extortionately more than what might be deemed to be a reasonable administrative burden and for the purposes, the objectives that this was set out to achieve in the first place. And for that, we will dive in a moment to this Supreme Court case. And next, we consider whether it's a penalty or whether it's unfair. Now, considering those, we will need to dive into this law here. So let's go to this Supreme Court case here. This first discussion, so the Supreme Court was tasked with deciding, first of all, whether it was a penalty, because obviously a company should not be able to issue you a penalty. Those are reserved for local authorities and things like that. And secondly, it went on to consider whether or not it was fair. Now, against the backdrop and the penalty rule, the Supreme Court said against this background, it can be seen that the £85 charge had two main objects. One was to manage the efficient use of parking space in the interests of the retail outlets and of the users of those outlets who wish to find spaces to which they can park their cars. This was to be achieved by deterring commuters or other long-stay motorists from occupying spaces for long periods of time or engaging in inconsiderable parking practices, thereby reducing the space available to other members of the public, in particular the customers of the retail outlets. The other purpose, was to provide an income stream to enable Parking Eye to meet those costs of operating the scheme and to make profit from its services, without which those services would not be available. These two objectives appear to be perfectly reasonable in themselves, subject to the penalty rule and the regulations. The imposition of a charge to deter overstayers is a reasonable mode of achieving them. Indeed, once it's resolved to allow up to 2 hours free parking, it's difficult to see how else those objectives could be achieved. And then the court went on to conclude that, in our opinion, while the penalty rule is plainly engaged, as in it is certainly something to consider, the £85 is not a penalty. The reason is, and this is the bit that I'm reading from here, the reason is that although Parking Eye was not liable to suffer loss as a result of overstaying motorists, a contention brought up in many of the comments, it has a legitimate interest in charging them, which extended beyond the recovery of any loss. The scheme in operation here, and in many similar car parks, is that the landowner authorised Parking Eye to control access to the car park and impose the agreed charges with a view to managing the car park interests in the interests of the retail outlets, the customers and the public at large. In other words, the Supreme Court said this was not a penalty because it was a reasonable charge to levy to deter customers to achieve those objectives. In other words, to keep the car park being used for what it was intended for, which was the retail outlets, to deter long-term parkers or abusive parkers, commuter car parkers, and all that sort of stuff. So the Supreme Court said it was not a penalty, therefore it is not unlawful in that respect because it's not a penalty. The court then went on to consider whether or not it was unfair, and that's a bit further down here. The regulations in respect of fairness of terms within a consumer contract are found under the Unfair Terms in Consumer Contracts Regulations, 1999. And the fairness test here, it provides under Regulation 5.1 a contractual term which has not been individually negotiated shall be regarded as unfair if, contrary to the requirement of good faith, it causes a significant imbalance in the parties' rights and obligations arising under the contract to the detriment of the consumer. And Regulation 6.1 provides that the unfairness of a contractual term shall be assessed taking into account the nature of the goods or services for which the contract was concluded, and by referring at the time of conclusion of the contract to all the circumstances, and this is a key point, all the circumstances attending the conclusion of the contract, and to all other terms of the contract of another contract on which it is dependent. And the court concluded, in our opinion, for the same considerations shown that it's not a penalty, demonstrate that it's not unfair for the purposes of the regulations. Now, in other words, taking into account all of the circumstances and all of the considerations and the balancing rights of the parties, the rights of the parties versus the rights of the landowner to manage that land and the licenses that it grants for the parking and so on, the court relied on its own conclusion that it was not a penalty to support the same conclusion that it was not an unfair term for £85. As I said, if these companies then started charging you £500, then that is much more likely to be a significant imbalance of the parties, as is described here in the fairness consideration of the regulations. It's much more likely to be unfair if it was, let's say, just for example, £500 as the instantaneous parking charge notice for breach of the contract. Likewise, if there was any other sort of, you forfeit your vehicle if you park badly, obviously that would be unfair. It would be significant imbalance for the motorist to say, if you park badly, we're going to take your car away and crush it. Clearly, that is a significant imbalance between the rights of the parties and the obligations under the contract. Of course, it's to the detriment of the consumer, but it's a significant imbalance. So no contract is going to allow that. Now, at the same time, many people have made the argument that if you put a notice on your car to say, I don't agree with the terms of the contract, that's not going to go anywhere because you are impliedly accepting the terms of the contract by your conduct by parking on the car park in the first place. And much like if you put a sign to say you'll give me £1,000 if you give me a fine or whatever, or parking charge notice, it's not a fine. Many people see it as a fine. But if you were to put a sign like that on your car, then that, for the same reasons, although not under consumer law, but it would be under a different bit of law, it would still be unfair because it's an imbalance of the parties that was not individually negotiated. So nice try, but it's not going to work. So all in all, even if you've parked on a car park and you are a customer and you've been in, but you've overstayed, let's say, a 3-hour limit, which was more than one message that came to me with the same question, hence the video, that is still not going to be unfair and unenforceable as a parking charge notice if you've overstayed that amount of time. But as I said, if any of the other things apply, the signs weren't there, the signs weren't clear, the address wasn't given properly, the writing was too small, they're charging too much, or they're only giving you like 5-10 minutes or whatever to park before this is applied, then all of those reasons might make it unfair, even though this case went to the Supreme Court and said, right, in this set of facts, we don't think it's a penalty and we don't think it's unfair. It's interesting to note that there was a dissenting judgment here. It was a majority ruling, so maybe I'll come back to some of those interesting comments in another video, because very often, sometimes barristers might use dissenting judgments and comments to support a claim that contrasts the instant claim with an authority such as this one. So those are interesting things to consider, and they will obviously be very dependent on the facts, but ultimately, it might not be what you want to hear, but even if you are a genuine customer and you've overstayed, it's still not going to be an unfair penalty charge, parking charge notice. Penalty is the official fine kind. Another video. Now, finally, I would always urge you to be reasonable and communicative with the shop and the parking company. Now, the parking management company are going to have a contract with the shop to get paid a commission and so on. That's between them. But if you were to contact the shop and say, look, I'm a really good customer here. Just this once in all the years I've been coming here, I'm 5 minutes over. Please let me off. They might then have a conversation with the parking management company and say, look, we'll pick up your commission for this one, but don't fine them. Or, not fine. It's not a fine. And just waive the parking charge notice. And finally, if you genuinely do have a ticket for the time and that you genuinely weren't over the time and you genuinely weren't in breach of any of those terms, then challenge it. Because if you can show that you were not breaching the terms, such as my previous example, I had a permit and it was on display, they are reasonable. I have to be fair. The company that I wrote to and said, look, this just blew off onto the chair. So I was displaying it. They just didn't see it. They should have seen it. And they were perfectly fair. So I hold no grudge against that company for issuing it. I just think they shouldn't have. I think they should have had a little glance around. They don't need to go hunting for it, but they should have glanced around, seen that it was there on the seat and like, it's blown onto the seat, but the guy does have a permit. So not issue the parking charge notice. So if any of that's helpful, please do bop that like button and subscribe. And as always, have yourself a great weekend. I'll see you next time.